Thank you. And thank you to everyone here for the invitation to speak on a matter of great importance to my community, which is the Comox First Nation, and in fact, all Indigenous communities, whether under the Indian Act, Land Code, or self-governing under a modern treaty. I'd like to start with the following statement. Self-government and the rule of, self-government and the rule of law are meaningless, empty slogans if First Nation laws cannot be enforced. The Crown has the necessary tools to enforce their laws. Federal and provincial governments are well financed and equipped with police forces, prosecutors, and courts to ensure their laws are enforced. Enforcement of First Nation laws is complex because the right enforcement tools are not available and capacity for enforcement is not yet developed with First Nations. In British Columbia, the RCMP will generally not enforce First Nation laws because the Provincial Prosecution Service will not prosecute offences under First Nation laws, whether they are bylaws under the Indian Act, Land Code laws, or laws enacted by treaty nations. This is because they are not enactments for the purposes of provincial law. The Comox First Nation has helped fill this jurisdictional void by addressing the unenforceability issue head-on in court in 2018 with the Comox First Nation versus Thordarson and Sorby decision. Comox had a lessee, Ryan Thordarson, and his wife Amelia Sorby, who refused to pay rent to a certificate of possession holder, landlord, so his lease was terminated and he was evicted, but he still refused to leave. By refusing to leave, he had committed a land code offense because he had no lawful right to be on our lands. He was thus issued a notice of trespass by myself under our land code, which is a quasi-criminal offense. I should state that the difference between Indian Act laws or bylaws, I should say, and land code is that the authority is given or transferred from Canada to First Nation land code nations to develop laws and to have those enforced. And so that's where this confusion seems to come in. So the RCMP said they could not remove Thordarson or charge them under the land code offense. They would attend and keep the peace, as our laws were not, and I quote, real laws. The Crown would not prosecute, as they didn't recognize our laws, and they did not recognize the authority that we had to create the laws. And these are not bylaws, these are laws. So Comox had a difficult decision. We had someone squatting on our land illegally, so we decided the only way forward was to charge and prosecute the offense itself via criminal code provisions, allowing for a private prosecution of a criminal offense. Unheard of. The court was baffled and unfamiliar with the land code and the authority granted to develop and enforce laws under the framework agreement of the First Nations Lands Management Act. After 10 months in court proceedings, the court eventually got to the understanding and ordered the police to remove the trespasser. This carried significant costs to Comox in legal fees for private prosecution in the ballpark of $178,000. The trespassers got 10 months of free rent and were fined $1,000 each. Hardly an equitable decision. It was an extremely costly process, and we should not have had to go to court to get that court order. Just this week, and in fact today, we have another trespasser on reserve who was issued a notice of trespass by myself and an RCMP officer 2 days ago. And we are not hopeful that he will leave. And in fact, he has dared us to take him to court. So we could potentially be looking at another costly court case. So with the court decision in Thordarson in favor of Comox, the question of enforcement should be a non-issue, and the RCMP should be there to enforce the matter. However, we've been told by the RCMP lawyer that they have not been granted that direction from higher ups within the RCMP. While our relationship with the RCMP has drastically improved due to a change in inspectors, their hands are tied at the moment with regard to enforcing laws because of the lack of direction from above. A big selling feature of the Land Code Framework Agreement is being self-governing on our reserve lands with the ability to create our own laws and have them enforced and recognized in courts, which wasn't happening under the Indian Act. Funding also remains an issue to develop laws and enforce. A secondary issue that we have is that Comox is also in the 9th year of Stage 5 treaty negotiations, and we recently held a forum on First Nation law enforcement in partnership with the BC Treaty Commission. This forum included land code nations, nations negotiating treaties, and self-governing nations, as well as police officers, and representatives from the Attorney General's office, federal and provincial. What we learned was that nations such as Manalf and Tla'amin have been struggling with enforcement issues as treaty nations, and neither have successfully prosecuted a single offense under their laws. To date, the only modern treaty nation to successfully address an enforcement issue is Tsawwassen First Nation, who have a very costly enforcement agreement with the Delta Municipal Police. To be self-governing, First Nations need to have proper enforcement tools, including an adjudicative body, enforcement services, and capacity for policing, and mechanisms that harmonize with the provincial court administrative systems. We are trying to achieve the above through our land code by creating things like community protection laws and adjudication laws and a justice tribunal, and also through our treaty negotiations, because we are very close to voting on a treaty. And this is, if we're dealing with this under land code as a self-governing portion under the Indian Act, then how is this going to work out for treaty? And so far, modern day treaties only provide the first of these tools, and that is lawmaking, and that's the same with the land code. And so before closing, I just want to refer back to the enforcement forum that was hosted by the BC Treaty Commission. This forum had a number of recommendations, and I'm happy to provide that to whomever I need to provide that to so that that can be shared. But there are a number of recommendations, including needing language in the treaty to ensure that First Nation laws under treaty can be adjudicated under First Nation Justice Tribunal with regards to mechanics of enforcement. We need to change the treaty language and provincial law to clarify that First Nation laws are enactments for the purpose of Provincial Court Act to allow filing of a First Nations Justice Tribunal order to have it come to the order of court to trigger court enforcement mechanisms. And then regarding policing and enforcement agencies, we have tried for years to negotiate a tripartite agreement with the province of BC and the RCMP, and we've been told repeatedly they no longer do these tripartite agreements. I understand that may be changing, and I really hope it is, because these, the issues that we're facing here in Comox with drug dealers, people trespassing, I shouldn't be in these people's faces. Thank you. Thank you for your time.